starting in 2 minutes. If you haven't turned your phone on, go ahead and do that for me. It should be completely off, not on vibrate. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for this special business. God save the state and this honorable court.
Welcome. We appreciate your being here today. Next case is State versus Benner, and we will hear from the appellant.
May it please the court, I'm Gordon Widenhouse. I represent Matthew Benner in his appeal to this court from the grant of a petition for discretionary review after an adverse decision in the Court of Appeals that affirmed his first-degree murder conviction and sentence of life without parole. I'd like to try and reserve 5 minutes for possible rebuttal. There were several issues presented in Mr. Benner's petition for discretionary review, but the principal issue in this case is whether the Court of Appeals erred in affirming the murder conviction where the trial court gave an incomplete instruction on self-defense. Mr. Benner had used a gun to defend himself in his home against an unarmed assault, but the trial court omitted language from the requested pattern jury instruction that if he was in his own home, the defendant could repel force with force regardless of the character of the assault made upon him. As this court has said in State v. Lee, State v. Bass, and most recently State v. Coley, where a defendant is entitled to a self-defense instruction, he is entitled to a complete self-defense instruction. And where a complete self-defense instruction is not given, a new trial is required. Therefore, this court should reverse the Court of Appeals and order a new trial as it did in Lee and Bass and Coley.
Is this issue properly before us
I think it is, Your Honor.
in terms of preservation?
I'm sorry?
In terms of preservation, is it properly before
Well,
us?
the pattern jury instruction 308.10 was requested at trial, and that request was renewed after the trial court declined to give it. That issue was raised in the Court of Appeals, the failure to give the pattern jury instruction, and so I think it's completely preserved. Preserved at trial and preserved in the Court of Appeals.
Was there a request for 308.80?
There was not a request for 308.80.
Help me understand it. It seems to me the first of the two substantive issues that you've tried to argue to us involves 308.10, and the second involves 308.80. Is that right?
I don't think it involves necessarily 308.80. It involves whether the statutory entitlement to a presumption of reasonableness would apply.
Where the second of the issues, which is the presumption of a reasonable fear, where was that raised in the trial court?
In my reading, it was raised in the charge conference where the defendant is asking for 308.10.
So just apologize for interrupting you, but I
Right.
lose your train of thought or mine. So your argument then is that by requesting 308.10, the defendant effectively requested both of the instructions that you were arguing in your brief?
I'm not arguing he requested 308.8. He did not request that instruction.
Is the reasonable presumption language in 308.10?
No.
Okay.
But I think that by requesting that instruction, and the colloquy at charge conference immediately was, the defendant is a felon in possession, he's committing a crime, he doesn't get the benefit of the statute. And that prohibition is a prohibition against the presumption language. So I would agree, I think, with what Your Honor is saying, that the colloquy at the charge conference is not a model of clarity. He certainly did not request 308.8, and we've never contended that.
The Court of Appeals held that you had not preserved properly the reasonable presumption issue. I didn't see that raised in a challenge to that holding raised in the petition, was it?
Again, it was perhaps not as clearly as if I had it to do over again, I would raise it. But
Hindsight's always great, isn't it?
isn't that the truth? But part of what was going on, I think, in the colloquy at the charge conference was they wanted the stand your ground statute language, which would include the presumption. When the Court of Appeals said no to that, they said, well, you don't get it because you didn't request 308.80. You didn't request that pattern instruction, so you don't get the presumption. You don't have to request that pattern instruction to get the presumption. And I thought the colloquy at trial, especially when everyone immediately leapt to the point that he's a felon in possession, so he doesn't get the benefit of the stand your ground statute, that preserved the issue of the failure to instruct on the presumption. Now, again, it's not as clear as, and I think, let me drop back a second. I think one reason defense counsel wouldn't have asked for 308.80 is that's labeled a defense of habitation instruction. And the defense theory at trial wasn't defense of habitation. It was plain self-defense. And so he requested 308.10, which is an important part of a self-defense instruction, where the self-defense act happens in the home. Because under that requested instruction, there are two things that are important in that requested instruction. One is you don't have a duty to retreat when you're in your own home. Now, he did get a no duty to retreat instruction in this case. But the second thing is you can respond with greater force when you're in your own home than the force that's brought to bear upon you. That was very important in this case because Mr. Benner's, all the evidence, Mr. Benner's own testimony was he wasn't assaulted with a deadly weapon. It was a physical assault. He then got a gun, continued to order Mr. Dry to leave the house. Mr. Dry rushed him at that point, again, physically assaulted him at that point, and it was at that point that Mr. Benner shot him twice. So it's important for the jury to understand on those facts that he can respond with greater force than the force that was brought to bear upon him. So that's the common law of self-defense. It's articulated in State v. Francis, which we've cited in the brief, and Francis says where the trial court said the opposite, that you could not respond with deadly force to a simple assault, even in your own home, that was error, and Francis received a new trial. There weren't pattern jury instructions at the time of Francis, so judges were sort of on their own to come up with an appropriate instruction. But the point of Francis is that the common law entitled him, and entitled Mr. Benner in this case, irrespective of any stand your ground statute, the common law entitled him to use greater force in his home to defend himself than the force that was brought to bear upon him by the other person. So again, it's not a defensive habitation situation here, it's a self-defense situation. And in a case where a defendant requests an instruction on self-defense, this court and the Court of Appeals was required to take the evidence in a light most favorable to the defendant.
So your preservation argument then is, if I'm understanding it correctly, that essentially by requesting a self-defense instruction, that request encompasses all components of a self-defense instruction involving a person within their own residence?
Okay, I want to make sure I answer that correctly from my perspective.
Well, I hope you will.
He requested a self-defense instruction that incorporated language about you don't have a duty to retreat,
Right.
and you can respond with greater force, including deadly force.
And that's in 308.1.
That's in 308.1. So that's the language that we wanted in this case, and I think was required in this case. And the Court of Appeals, I think, got it wrong to say it wasn't required. With regard to the second issue, the presumption issue, and that language, my argument is I think it was preserved by the colloquy at trial, given the fact that everyone immediately started talking about whether one of the exclusions to that presumption language applied.
Do you admit, though, that it was not expressly requested?
It's not specifically requested. I've looked at the transcript more times than I care to admit, and I can't find the word presumption in the charge conference. So I'm not saying that it was specifically requested with that language. I'm simply saying that I think it was clear to everybody at the charge conference that was what was going on.
So, Mr. Whitehouse, just a quick little question about that. The state contends that if it's not clearly enough stated in the charge conference, that the alternative is to argue it as plain error, and that y'all haven't done that.
Well, I agree. If the court agrees with the Court of Appeals that in order to preserve the issue about presumption language, more needed to be done, and I needed to argue plain error. I did not argue plain error. I didn't argue it in the Court of Appeals. I'm not arguing it here. So if that's what's required, then I didn't do what was required. I didn't argue plain error with regard to that issue.
But your position is that we can see enough to understand that that issue was before the court based on what's in the charge conference?
Well, all I can tell you is I saw enough. I mean, or I wouldn't have raised the issue the way that I did, and probably would have argued plain error. I thought that the colloquy made it reasonably clear that that's what everybody was talking about. They were talking about the Stand Your Ground statute, and the important part of the Stand Your Ground statute, I think, is the presumption of reasonableness. It changes the nature of your entitlement to the defense if you're reasonable, if your actions are presumed to be reasonable. Certainly it's a rebuttable presumption. But even if I don't think the court has to get to the second issue in this case. I think the court should resolve the case based on the first issue, a requested instruction that stated the common law. And where I think the Court of Appeals went awry was when it first begins to discuss this issue, the Court of Appeals said, well, let's see, how did the Court of Appeals say that? Said that the requested instruction flows from the Stand Your Ground statute. And that's just wrong. The requested instruction in this case existed as a pattern instruction as far back as 1985 when this court quoted that language in State v. Morgan.
So then what is your position regarding the interplay of the common law and the statutory stand your ground law given what you've just said, that the requested instruction is based on the common law? Doesn't the stand your ground law then still apply? It modifies it?
Well, it can modify the common law, but it doesn't change aspects of the common law that it doesn't specifically change.
Right. So I guess then my question is, if that's true, the felony disqualifier in the stand your ground law also would apply to the common law instruction that was requested?
I don't think so. I think the felony exclusion applies to the stand your ground statute. That's where it is, and there's language in the stand your ground statute that says nothing here is changing the common law. The common law continues to exist. And there's nothing, and again, I think that's a reasonable interpretation because the legislative purpose behind the stand your ground statute was to broaden a person's right to self-defense and defense of habitation in the home. It wasn't designed to narrow it. The whole purpose of giving a party a presumption of reasonableness is designed to expand your right to self-defense, not contract it. So there's the legislative purpose behind the stand your ground statute wouldn't be to modify the common law, absent some language in the statute that this aspect of the common law we're going to change.
How do we square that with Crump?
I'm sorry?
How do we square what you just said with Crump in terms of the principle that only one who is obedient of the law at the time self-defense is being exercised can get that recognition?
Because the language in Crump is interpreting a provision of the stand your ground statute that applies to the stand your ground statute itself. In other words, a person who is committing a felony at the time of the defense in his home isn't entitled to the presumption of reasonableness. That exclusion, that contraction, is a contraction of something that's being granted in the stand your ground statute. Otherwise, it makes no sense for the statute to say this doesn't change the common law. I mean, it would need to be.
How would you propose that a trial, I'm going to hit you with a strange hypothetical, and let me see what you think a trial judge is supposed to do with it. You've got somebody in Mr. Benner's position in this case. Mr. Benner says, I want to, in this, put aside the felony exclusion for a second. I want to invoke both my common law right of self-defense and my statutory right of self-defense in my home. Is the trial judge supposed to give two different self-defense instructions if the defendant invokes both of the sets of legal principles?
I think the self-defense instruction in that case would need to incorporate both parts of the stand your ground statute that apply on the facts, as well as aspects of the common law that haven't been eradicated by this court or specifically eradicated by a statute.
So your contention is that the trial court effectively ought to deliver a combined instruction? It merges,
yes,
the two
for
sets.
example, I think in this case, the trial court gave, as part of its self-defense instruction, no duty to retreat.
Right.
It didn't give the defendant can use greater force than the force that was brought to bear on him. The trial court could have added that consistent with 30810 without making the self-defense law non-understandable, and it would have covered the basis.
What are we supposed to make of the fact that the preservation of the common law provision is found in 51.2 but not 51.3?
Well, I think it would mean that the preservation of the common law isn't changed by anything that's in 51.2, I guess one could surmise that perhaps it's changed by 51.3.
So essentially, you would have multiple types of self-defense available in the factual situation covered by 51.2, but not 51.3?
I would think there could be facts where 51.2 would apply and 51.3 would not,
Or vice versa?
and vice versa. And again, the hypotheticals are interesting, but it doesn't change what I think is a straightforward issue that the defendant requested an instruction that was consistent with the common law. Nothing about what's in that requested instruction is changed by any part of the Stand Your Ground statute. Now, there's nothing in the Stand Your Ground statute that says, after we pass this act, you're no longer free to respond to a physical assault with a deadly weapon.
Is there anything in the trial court's instructions that would have suggested to the jury that the nature of your client's rights would have varied based upon whether the assault that your client testified that Mr. Dry committed upon him was committed with or without a deadly weapon?
I missed the last part.
I'm sorry, and I apologize for that.
I'm missing a hearing aid.
I swallowed one of my words, which is the reason that you had the problem. Is there anything in the instruction that the trial court did give that would have suggested to the jury that it made a difference whether Mr. Dry used a deadly weapon at the time that he assaulted your client?
In a way.
Okay, tell me where in the instruction I would find the "in a way" that you just...
Well, I think when the trial court says you're not entitled to self-defense, a perfect self-defense, if you use excessive force.
Does that change based upon whether there's the use of a deadly weapon or not by Mr. Dry?
Not necessarily, but it would be, I think, a jury, and this really is sort of the nub of my argument, I think, amazingly. When a jury knows that a person responds with a deadly weapon to a simple assault, nothing else appearing, and they're told you have to decide whether the defendant's actions, his fear of death or serious bodily injury is reasonable, and whether he uses excessive force. Nothing else appearing, I think reasonable people would say, if you respond to a simple assault with a gun, that's excessive force. If you respond to a simple assault with a gun, that's an unreasonable reaction to your fear. Your fear of death or serious bodily harm is more likely unreasonable if I'm standing there with a gun and somebody approaches me using their fist. My fear, the reasonableness of my fear of death or serious bodily harm, it seems to me, goes down, nothing else appearing, which is why it's important for the language to be given that a person who is defending himself in his own home can respond to non-lethal force with deadly force.
Is there anything in the instructions as given that says that the defendant was not entitled to use deadly force solely because of the fact that he was assaulted in a manner that involved fist or body parts or whatever as compared to weapons?
No. If that language was in the instructions, I'd say Francis is controlling, end of discussion.
Okay.
Because Francis specifically holds that's inappropriate. But my point is that's essentially what happens when you don't tell the jury that is charged with finding whether the defendant's belief of death or serious bodily harm is reasonable and is charged with determining whether the defendant's force is excessive under the circumstances. That's why the jury can make those determinations. The jury could hear the evidence in this case and under proper instructions perhaps conclude Mr. Benner's force was excessive. But I think if they conclude that, the result is voluntary manslaughter, imperfect self-defense, not first-degree murder. They could also conclude his belief of death or serious bodily harm was unreasonable. The jury gets to make those decisions. But the jury has to make those decisions only after they're given an appropriate instruction as to the law, which is why, in my view, on these facts, it was so important for the defendant to get the language out of the requested pattern jury instruction, because that tells the jury that they make these determinations about reasonableness and unreasonableness as excessive force and non-excessive force under the law, that a person can respond with deadly force to non-deadly force if he is in his home. And the jury was never told that. And without that, the jury's determination of excessive force, if they found that, we of course don't know, that whether the defendant's reaction and fear was reasonable. We don't know exactly what they found, except they convicted of first-degree murder. And again, I go back to the language in Lee and Bass, and most recently Coley. If you're entitled to a self-defense instruction, you're entitled to a complete self-defense instruction. And on these facts, a complete self-defense instruction would have included the language that was requested in 308.10. And without that, the jury's verdict is just simply not reliable, as this court essentially concluded in Bass and Lee and Coley.
Mr. Whitehouse, if I may, 1451.2, would you agree encompasses the statutory self-defense and common law self-defense?
I think it encompasses both, but I don't think it changes common law principles that it doesn't specifically say it's changing.
And would you also agree that 1451.4 provides exclusions to the use of that justification?
Yes,
Use of self.
I would agree that. Yes.
And does your argument on 1451.4 and the felony disqualifier require us to conclude that the legislature intentionally or inadvertently legalized possession of a firearm by a felon?
No, I don't think so.
Okay, why not?
Because my argument is there needs to be a causal nexus between the felony that's being committed and the shooting that's in self-defense.
Would you agree that your client could be charged with possession of a firearm by a felon stemming from this event?
Yes. Yes. But just because he can be charged with a crime based on facts doesn't mean that that particular crime is causally connected to the shooting. And that's the point that we're trying to make in that particular issue. Thank you.
Thank you, counsel. We'll hear from the appellee.
May it please the court, my name is Joe Hyde. I represent the state in this matter. This case is before the court on the basis of the defendant's petition for discretionary review to review the unanimous opinion of the Court of Appeals finding no error in his conviction for first-degree murder. Not to retreat is to stand one's ground. In his reply brief, defendant acknowledges as much. It's on page 4 of the reply brief. He says this notion is correct. It means the same thing, not to retreat, to stand one's ground. Here, the trial court instructed that defendant had no duty to retreat. The only issue on the merits addressed by the Court of Appeals is whether the defendant was entitled to an additional instruction on his right to stand his ground. Since the trial court gave the requested instruction in substance, since the trial court told the jury that defendant had no duty to retreat, the Court of Appeals did not err in ultimately approving this instruction.
If I'm understanding Mr. Widenhouse's argument, he's got a few minutes to correct me if I am not understanding it. I think his response to your argument that the two are one and the same is in effect that if the jury is not told that you can use deadly force to resist an assault committed upon you in your home, even though no deadly weapon was used as part of that assault, that the jury is likely to misunderstand the extent to which you did or did not use excessive force, and that's why your argument that the two are one and the same has no merit. Again, if I've misconstrued his argument, he can correct me, and I hope he will. But assuming that that is his, for starters, if you hear him differently than I do, let me know.
No, I think you're right.
Don't hear him differently than I do, why do you contend that we shouldn't accept that argument?
Right, let me address that on two different bases, because there's sort of a procedural angle and there's a merits angle. The first is that that's not really the argument that was presented to the Court of Appeals. I think you're right in how you characterize defendant's response to the state's argument. That appears on page 4 and 5 of his reply brief. He says in a footnote, he summarizes the state's position, says it doesn't matter because he's concerned with that language in 308.10 about regardless of the nature of the assault. So I think you're right in how you're characterizing that. But as I said,
Well, I'll let you get to the procedure in a second, but as a matter of the merits, assuming that we got there, why would you argue that we should not accept that contention?
yes, Your Honor, on the merits, and in an issue that the Court of Appeals did not rule on, the simple fact is that proposition is neither correct in law, nor is it reflected in the requested instruction. The suggestion that a defendant in his home is permitted to use deadly force in response to a non-deadly assault is simply not the law. That provision about regardless of the nature of the assault is meant to condition the rule that a defendant has a duty to retreat outside of the home when he's subject to a non-deadly assault, but he does not have a duty to retreat in the home, regardless of whether he's subject to a deadly assault or a non-deadly assault. The phraseology, regardless of the character of the assault, is not modifying force. It's modifying stand the defendant's ground. That's very clear from Pearson. If I can read a portion of this court's opinion in Pearson, another distinction applicable to the deadly force, non-deadly force dichotomy is made between assaults with felonious intent and assaults made without felonious intent. And the latter, the person assaulted, may not stand his ground and kill his adversary if there is any way of escape open to him. That is to say, a person outside of the home, subject to a non-deadly assault, has to retreat before he resorts to deadly force. These retreat rules have no application, however, when a person who is free from fault is attacked within his own dwelling. In this type of situation, the law imposes no duty to retreat as a condition to exercising the right of self-defense, regardless of the character of the assault. The regardless of the character of the assault language refers to the duty to retreat. You have a duty to retreat from a non-deadly assault outside of the home, but not inside of the home. That does not mean that a defendant in his home is permitted to use deadly force in response to a non-deadly attack in the home. That's clear from the caveat that always follows this provision, that would not excuse a defendant for the use of excessive force. Now, I think Your Honor asked opposing counsel, where in the instructions did the trial court suggest that this right of self-defense was somehow modified or conditioned upon the nature of the assault? And he said, well, it appears in the provision about excessive force, when the trial court said a defendant is not permitted to use excessive force. If that provision somehow suggested an erroneous conclusion, then the inclusion of pattern instruction 308.10 would not help him in the least, because 308.10 also includes that language. The last line, however, the defendant would not be excused if the defendant used excessive force.
So if I'm understanding it, I'm just trying to make sure I understand your contention, Mr. Hyde. If your argument then is that this instruction has no bearing on the excessiveness or lack of excessiveness of the amount of force used by the defendant?
I think that's correct. What it has a bearing on is that distinction that exists outside of the home between the right to stand your ground in response to a deadly attack, but not to stand your ground in response to a non-deadly attack. And as Frizzell and Francis make clear, it's necessary to include this instruction only when the trial court has first advised the jury that a defendant does have a duty to retreat or may have a duty to retreat from a non-deadly assault, that's where you get a deprivation of this common law right that could be prejudicial to a defendant. But where the trial court never said, you know, the response is dependent upon the nature of the force, he has to retreat in these circumstances and not in those, this explanation, but if he was in a house, he does not have a duty to retreat regardless of the nature of the assault, it doesn't have any meaning, because that condition hasn't been instructed ahead of time such that that condition is triggered.
Well, this instruction does, I hear what you're saying about whether or not it's suggesting you can use deadly force, but it does say more than just you can stand your ground. It does, I mean, you would agree there's a difference between just standing and doing nothing and the act of using force.
I would.
And unlike the instruction that was given, the instruction that was requested includes and repel force with force regardless of the nature of the assault. So it's saying you can do more than just stand there, you can use force.
And the instruction that, Your Honor, you're absolutely correct about that. The instruction that was given also advised the jury of the same principle. The instruction that was given said the defendant would be excused of first-degree murder and second-degree murder. I'm looking at page 38 of the record. If the defendant believed it was necessary to kill in order to save the defendant from death or bodily harm, and the circumstances as they appeared to the defendant were sufficient to create such a belief, the defendant would not be guilty if the defendant acted in self-defense. This is analogous to the situation in a case called Jordan. What happened in Jordan was the trial court instructed the jury on self-defense, and the trial court instructed the jury that the defendant had no duty to retreat. And on appeal, the defendant complained that the trial court didn't also instruct, didn't say further, that under such circumstances, the person assailed would have a right to kill his adversary without retreating. And what this court said was the instruction already communicated that. The general right to use force in response to an assault is stated in the instruction without qualification. The jury was instructed that the defendant had no duty to retreat. The trial court need not then go back and say again, furthermore, you don't have to retreat before you use deadly force, because that's already packed into the bundle that has been given to the jury. That's what happened in Jordan. That's what happened, that's what defendant is asking this court to hold here, to come out a different way, because he says essentially the same error happened in this case. He was entitled to this further instruction that he had a right to use self-defense. He's entitled to a further instruction that he need not retreat. It's already there. It's in the instruction that was given to the jury. And this court has said that jury instructions need not be redundant. Instructions are sufficient if the substance of the request is included in the instruction that's provided to the jury. The substance of the instruction was provided to the jury here.
So would it be fair to read in the jury's verdict that if it had believed that there was excessive force used, it would have found the defendant guilty of voluntary manslaughter? In other words, I'm looking at the jury instruction that was given that says if the state fails to prove that defendant did not act in self-defense, you may not convict the defendant of either first or second degree murder. However, you may convict the defendant of voluntary manslaughter if the state proves that the defendant used excessive force.
That's right, Your Honor. That's precisely correct, which indicates to me that even if this was error, it couldn't have been prejudicial, because the suggestion of opposing counsel is this additional language about the use of force regardless of the nature of the assault is somehow affecting the calculus of the excessiveness of the force. If the jury needed that additional instruction under Your Honor's reading, they necessarily would have found the defendant guilty of voluntary manslaughter by finding that the force used in this case was excessive. That's not what the jury did. They rejected self-defense entirely, which means the rationale must have been based, the verdict must have been based on the rationale that the defendant did not reasonably believe that it was necessary to use deadly force in this circumstance, if that makes sense. Self-defense applies if the defendant reasonably believes it's necessary to use deadly force, and in addition to that, the force is not permitted to be excessive. If I understand opposing counsel's argument, it's that this language about regardless of the nature of the assault is somehow relevant to the finding of excessive force. But as Your Honor points out, had the jury found excessive force only, everything else being equal, they would have found the defendant guilty of voluntary manslaughter. That's not what they did. They found the defendant guilty of first-degree murder, which means they necessarily rejected the claim of self-defense on some other basis than the excessiveness of the force here.
And Mr. Hyde, I had diverted you from your procedural argument, and I did want to hear that, so if you would let me have the benefit of that one as well, I'd appreciate it.
Yes, Your Honor. The two issues raised by the defendant before this court, I think Your Honor characterized first whether the trial court erred by omitting 308.10, and the second whether the trial court erred by omitting 308.80, although not in those terms, whether the trial court erred by omitting the presumption that appears in 308.80. The second issue is more problematic procedurally.
Well, are you making a procedural argument as to the first one?
I am, Your Honor.
Okay, that's what I wasn't sure about.
Okay. Yes, sir. The procedural argument with regard to the first one is that this argument is not the argument that was presented to the Court of Appeals. If you look at the defendant's brief, now I want to be careful about how I say this, because the defendant did quote the language of 308.80. There's no doubt about that. But that language that he quotes from 308.80, when he says this was the instruction that I requested, that is the only time in the Court of Appeals brief, it appears on page 17 of the defendant's Court of Appeals brief, that is the only time that you will find the words, regardless of the nature of the assault. The point being, defendant did not argue before the Court of Appeals that the crucial language here was that provision of the instruction qualifying the force or qualifying the duty to retreat. What he argued was this instruction 308.10 somehow, his request for 308.10 somehow alerted the trial court and opposing counsel that he was asking for an instruction on the presumptions established by 14-51.2. So the argument, we can we can argue about whether that additional language is pertinent to the duty to retreat or the amount of force, the excessiveness of the force. The Court of Appeals never actually addressed that question. What the Court of Appeals was addressing was, one, that he didn't request an instruction for 308.80 about the presumptions, and found he didn't argue plain error and need not address the merits of that. And then with regard to the instruction he did request, 308.10, what the Court of Appeals said was, it concluded the trial court did not err, this is on page 5 of the slip opinion, the trial court did not err by declining to instruct the jury on the stand your ground language provided in 308.10. The stand your ground language. The defendant's right to stand his ground is tantamount to the fact that he has no duty to retreat. It's the same thing. The trial court here instructed the jury that defendant had no duty to retreat. He was therefore not entitled to an additional instruction that he also had the right to stand his ground. It's gilding the lily. It's the same instruction again. So the procedural argument with regard to issue 1 is all of the argument about the importance or the significance of that language regardless of the nature of the assault. That argument was not presented to the Court of Appeals. The Court of Appeals simply did not rule on that. The only thing the Court of Appeals ruled on is whether the defendant was entitled to another stand your ground instruction, and it held correctly that he was not. Now, the procedural argument with regard to the second issue is more complicated because not only did the defendant not request an instruction on the 14-51.2 presumptions at trial, he also did not include in his petition for discretionary review to this court that the Court of Appeals erred by rejecting that argument. In fact, the Court of Appeals did not reject that argument on the merits. It rejected that argument because defendant hadn't requested that instruction. And I don't hear defendant arguing before this court that that was error. He never says the Court of Appeals erred in that regard. So, I mean, I guess I would agree with opposing counsel. This court need not address the second issue. That second issue is not before this court on two different bases.
What are we to make of the colloquy at the trial court when the instruction 308.1 is requested, and immediately all of the discussion is about whether or not the felony disqualifier applies?
I have asked myself that question again and again, and I do not have a good answer to it. I can't figure out precisely why everyone seems to have thought that this instruction had some derivation in those 2011 statutes. It may be because if you look at the pattern instruction.
I apologize for interrupting you, Mr. Hyde, but I want to make sure I'm following you. Is it your contention then that the felony exclusion in 51.4 has no application to the first issue?
That's correct.
Okay.
Yes. I agree with opposing counsel. I think this case can be decided on the basis of common law, and I think it would come out the same whether those 2011 statutes were enacted or not.
But it does appear that that was at least the trial court's understanding of why they were not giving this particular instruction.
It does, Your Honor. I would agree with that. And I'm embarrassed to admit that seems also to have been the rationale of the Court of Appeals. I think it may be because the pattern instruction cites 14-51.2 and 14-51.3 and seems to include a lot of footnotes with regard to cases that are decided under those statutes. But as opposing counsel points out, this court was citing that it's the same instruction with the same pattern instruction number back in 1986. So those statutes didn't really have any effect on this instruction.
So bottom line is your argument with respect to the first issue, and I know you keep trying to get to the second one and I'm not letting you, but your argument with respect to the first issue is essentially your argument that the substance of that instruction was given and we don't need to look any further, and that your position rises or falls with respect to that and your procedural contention that you gave me a minute ago.
I believe that's correct, but I would sort of divide the merits into two different points, because the instruction that was requested has these two different parts, right? On the one hand, 308.10 says, for the second time, the defendant can stand his ground. That particular idea, that concept, was included in the instructions that was given, right? Defendant now, for the first time before this court, says, well, the important part of that instruction is repel force with force regardless of the character of the assault. There's nothing in the instructions that was given that corresponds to that provision. But the state's position is that provision need not be given where there is no preliminary instruction that the right to respond depends on the sort of force that was used. That's clear from Pearson. That's the error, as I mentioned a moment ago, that appeared in Francis and Frizzell. There was a problem in those cases where the trial...
So when would it be appropriate to give that instruction? Tell me the circumstances. I think I know the answer, but I want to make sure I've got it right. When would that particular part of the instruction be required, appropriate, whatever word you want to use?
I think it could be relevant if there was a question of fact as to whether the defendant was on his own premises. That was not at issue here. I would like to say it comes into play only when the defendant is not on his premises or place of work or in his vehicle, because that's the situation where the degree of force he's permitted to respond with is contingent upon the force used against him. But in that case, you wouldn't have this caveat, but if the defendant's on his premises, then regardless of the nature of the force, he had no duty to retreat. So I think it would be relevant and applicable where there was a question of fact if the defendant was on his premises or not. Because only then would you have a situation where the lawfulness of his use of force could be, but not necessarily is, contingent upon the degree of force that's used against him.
So the text of the instruction itself, and I don't know to what way we give the notes, but it does say this instruction is to be used if the evidence shows that the defendant was at a place where the defendant had a lawful right to be.
Right.
So not if there's a dispute, and this is going to help the jury decide whether or not he was in such a place, but if the evidence shows that the defendant was at his home, in his car, in his workplace, then you give this instruction.
Well, that's what the pattern instruction says, but that's not the law, Your Honor. The question is whether the defendant is entitled to an instruction where it's a correct statement of the law and it's supported by the evidence. There's the argument here that the defendant was in fact entitled to an instruction that he had no duty to retreat. He got an instruction that he had no duty to retreat. He's entitled to an instruction that he's permitted to respond to force with the use of deadly force. He got that instruction too. That's included in the self-defense instruction. So this court is bound to ask, well, what was omitted? What substantive provision in this instruction did the jury not get? And the only answer to that is this provision about regardless of the character of the assault. And that language is triggered only where there's a question as to whether the defendant may respond to deadly force or not with deadly force, dependent on his duty to retreat. As in Francis, sorry, that didn't make a lot of sense. Let me try to say it a different way. The language about regardless of the character of the assault matters only when the use of deadly force is contingent upon the use of force used against the defendant, because he does have a duty to retreat outside of the home to non-deadly force. Does that make sense? Did I say it right?
Well, I guess what I still don't understand is, it sounds like you're saying this language of regardless of the character of the assault applies when he's not in his home.
That's right.
But the instruction is to be used when the evidence shows the defendant's in his home.
According to the pattern instruction, and the pattern instruction is not the law. You're right, Your Honor, that's what the pattern instruction says, but this court has said before, compliance with the instruction does not guarantee against error, and non-compliance with the instruction is not necessarily error. So whether the defendant was entitled to an instruction can't depend on whether, what do you want to call them, the instructions for the instructions were followed. It's true, this instruction was established by the Pattern Jury Committee to apply in those circumstances. But that doesn't necessarily mean that in those circumstances where this instruction is not given, that it is error.
Right.
In this case, it's because the essentials of that instruction were included in the instruction that the trial court gave. And the parts that were not included have no bearing on this case. That regardless of the character of the assault language need only be included where there is a preliminary instruction that the defendant has a duty to retreat against non-deadly force, as in Francis and Frizzell. That instruction was not given here.
So this language would be required if you were out on the street somewhere?
Perhaps, Your Honor. I think at bottom, the fascinating legal question that is raised by this case, and what opposing counsel and I are disagreeing about, is he keeps saying that a defendant is permitted to use more force in the home than is necessary to repel the attack. There's no law that says that. Francis doesn't say that. Frizzell doesn't say that. With regard to the more recent cases he cited, Lee, Bass, and Coley doesn't have any bearing here at all. In Coley, the defendant didn't get a self-defense instruction whatsoever. Lee and Bass both deal with a situation where the trial court declined to instruct the jury on the duty to retreat. The trial court here instructed the jury that the defendant had no duty to retreat. The error that this court found in Lee and Bass did not occur here. The defendant wants to say that this additional language, regardless of the character of the assault, somehow means a defendant attacked in his home with non-deadly force is permitted to respond immediately with deadly force. The consequences of that doctrine would be devastating. The jury all of a sudden doesn't have to determine the reasonableness of the response. If your dinner guest bumps your shoulder, you can pull out a gun and shoot him. That's not the law. That's not what 308.10 says. The language, regardless of the character of the assault, refers to the duty to retreat. The defendant in his home has no duty to retreat, but the force cannot be excessive, and it's still up to the jury to determine the reasonableness of the force. It's still up to the jury to determine whether the force used is excessive. If this court needs an additional authority for that, it's Perkins, a treatise that's cited in the state's brief, footnote 1. Of course, one attacked at home is not privileged to kill as a matter of choice. There must be the reasonable appearance of necessity. But what opposing counsel and I are disagreeing about in terms of the law is that a defendant who's assaulted in his home does not have the right to use more force than is used against him. That's not the law. That's not in 308.10. Just real quick on that second issue, a request for an instruction under, well, it's the presumptions that appear in 308.80 that, and to be clear, the jury is not to be instructed that, defendant says in his brief, the jury is supposed to be instructed that there's a presumption of the reasonableness of the response or the reasonableness of the use of force used. That's not what the statute says at all. It says a lawful occupant of a home is presumed to have a reasonable fear of imminent death or serious bodily harm. Now, that might be pertinent to the reasonableness of the use of force, but that's not, strictly speaking, what the presumption is. It's a presumption that the lawful occupant of a home has a reasonable fear of imminent death or serious bodily harm. Now, the interesting sort of legal question, if we're going to depart from the common law for a moment, is whether 14-51.2 or 14-51.3 eliminated that distinction that exists at common law about the duty to retreat from a non-deadly assault. I think that it did not. I would caution, I don't think this court needs to address that question here, because as opposing counsel recognizes, a person committing a felony is not going to be entitled to these presumptions in any event. But in terms of the ability of the legislature to change the common law, was there an intent to erase that distinction about the duty to retreat? Like I said, I think there was not, because 14-51.3a still sort of divides the scenarios between the use of non-deadly force and the use of deadly force. And the case law from this court says the use of deadly force in response to a non-deadly attack is excessive as a matter of law. That's State v. Hunter. Now, Hunter is about an assault outside of the home, but I think the principle would hold. And I find support for that in the qualification that's included in the requested instruction itself. However, the defendant would not be excused if the defendant used excessive force. The fact that a defendant has no duty to retreat in the home does not give him carte blanche to use deadly force against any assault that's made against him. If there are no further questions, the state would respectfully request that this court affirm as modified the decision of the Court of Appeals.
Thank you, counsel. Rebuttal.
May it please the court, just a couple of points. First, I'm not limited in my Court of Appeals argument to my main brief. I get my reply brief as well. And apparently the Court of Appeals and Mr. Hyde didn't read the reply brief, because the reply brief is crystal clear that this is the language that we wanted and why it would apply here. So I think the issue of whether we were entitled to the pattern jury instruction is fully preserved in this particular case. With regard to whether the language of the requested instruction is really just about no duty to retreat, if that's the case, then the instruction has too much language in it. There's no need for the language that in your home you can respond to non-lethal force with lethal force. And I disagree with Mr. Hyde that that's not the law in North Carolina. I haven't seen Francis overruled by any case that he cites, and Francis is clear on that point. That's the reason that this pattern instruction eventually developed, because you can respond with greater force, including deadly force, when you're attacked in your home. And I realize there's a difference between that and excessive force. But the point that I've tried to make in my brief, and probably not as well in my oral argument as I would have hoped, is that when the jury is determining reasonableness of one's belief and determining whether force is excessive, it's not just a matter of there being no duty to retreat. It's a matter of what level of force I can use when I'm attacked in my home. That goes to both the reasonableness of my belief, it goes to excessive force. And that's the important part of this instruction. And there is nowhere in the instructions in this case, nowhere where the trial court tells the jury the defendant can respond with greater force than the force that's brought to bear on him. And that's what the court in Francis said you have to do. The jury has to know that if you're responding to an attack in your own home. That's what is critical about this case. And again, if you don't have that language and somebody responds with deadly force to non-lethal assault, it's almost always going to look unreasonable. But it's not necessarily unreasonable.
In Francis, wasn't there an instruction given that said that you couldn't use, in no circumstances in your home could you use deadly force to resist an assault committed without deadly force?
No, there's not an instruction that says you can't use deadly force. At least, I don't think so.
Okay.
Again, we're asking 12 lay people who haven't been to first-year law school and been taught criminal law and haven't read cases to understand when you can respond and whether your response is reasonable. And it's important for them to be told you can use more force than is brought to bear on you when you're defending yourself in your own home. It was requested, it wasn't given. That's not a complete self-defense instruction. We'd ask the court to grant a new trial.
Thank you, counsel. Thank you to both counsel. Madam Clerk.